A single car crash rarely results in a single lawsuit. It spawns dozens of distinct civil actions, personal injury claims, property damage, and multi-party insurance disputes. Courts face a recurring tension between clearing an overloaded docket and ensuring every individual litigant gets an unprejudiced trial. The Supreme Court shapes the procedural rules that dictate exactly how these competing interests are balanced. To manage an exponential influx of related cases, the rules of court provide a specific control mechanism, Rule 31. This rule operates through two opposing functions. Section 1 acts as the suture, consolidation. Section 2 acts as the scalpel, severance. Mastering exactly when to merge cases and when to cut them apart allows a practitioner to navigate complex, multi-party litigation without redundant trials. Consolidation is a procedural device that unites several actions pending before the same court into a single trial and judgment. The goal is to avoid a multiplicity of suits, prevent delays, and spare the parties from redundant costs. Before any merger can occur, there is an absolute foundational requirement. The distinct actions must share a common question of law or fact. To execute a valid consolidation, the court relies on three pillars, represented by the acronym CAP. C stands for Common Questions of Law or Fact, deeply intertwined. A requires the actions are actively pending. P dictates the merger must prevent unnecessary costs or delays. When these related cases are filed in different branches, a strict administrative rule applies. The case bearing the higher docket number, meaning the one filed later, is invariably transferred and consolidated into the branch handling the earlier filed case with the lower docket number. A judge executes this in three ways: recasting all existing cases into one, holding a single joint hearing for the existing cases, or exclusively hearing the principal case while suspending the rest until judgment. Consolidation is a judicial strategy designed to harmonize judgments and preserve finite court resources by treating related actions as a unified proceeding. Because consolidation is a discretionary power, a judge must deny the motion if merging the actions would result in prejudice, procedural complications, or further delay. Examinees frequently fail by assuming that consolidated cases must always be heard and tried simultaneously. Under the third mode of consolidation, the court can validly hear only the principal case, provided its judgment will effectively resolve the suspended dependent cases without the need for a redundant trial. Another major procedural trap for students is the mistaken belief that civil and criminal actions can never be merged. A civil case for damages and a criminal case for physical injuries arising from the exact same vehicular accident can be joined. The court applies different quantums of evidence simultaneously: preponderance of evidence for civil liability and beyond reasonable doubt for the criminal charge. This brings us to the doctrine of expedient consolidation. If a party files a petition to cancel an adverse claim on a property, and the opposing party files an action for specific performance over the exact same property, the Supreme Court dictates they must be consolidated.
Valid consolidation prioritizes expedient, holistic justice. As long as the differing legal standards are respected, the court will unify the proceedings to serve the best interests of the parties. The necessary procedural counterbalance is found in Section 2, known as severance or separate trials. Severance allows the court to isolate specific claims from the main action. It is deployed exclusively in the furtherance of convenience or to avoid severe prejudice to the parties. To determine if severance is appropriate, we use the acronym CAPS. Separate trials are ordered in the furtherance of convenience and to avoid prejudice that arises from mixing unrelated claims. This applies to specific pleadings, resulting in separate trials that prevent judicial confusion. A judge can sever cross-claims, counterclaims, third-party complaints, or isolate a single threshold issue before trying the entire merits. Pursuant to Rule 36, Section 5, this procedure can result in a separate judgment. This judgment disposes of the isolated claim, terminating that specific action, while the main controversy continues forward unaffected. Severance acts as a procedural quarantine. It ensures that a highly complex or unrelated sub-issue does not unfairly infect the resolution of the principal complaint. Like consolidation, severance has strict limits. It should not be granted if isolating the claims leads to a multiplicity of suits or a waste of judicial time through the duplication of evidence. The most common procedural error is attempting to sever a compulsory counterclaim. Compulsory counterclaims arise from the exact same transaction as the main complaint. Splitting them defeats the purpose of procedural economy and creates the risk of conflicting judgments on the exact same facts. Contrast that with a valid target for the scalpel, a simple collection suit where the defendant files a highly technical third-party complaint against an insurance company. The judge will sever the insurance dispute to prevent it from unjustly delaying the primary collection case. A court can also sever a distinct foundational issue, such as jurisdiction or prescription. If a judge holds a separate trial on prescription and the defendant wins, the entire massive fraud claim is dismissed swiftly without a lengthy trial. While severance protects against prejudice, a court will refuse to wield the scalpel if it unnecessarily bleeds a single controversy into redundant, overlapping trials. Rule 31 is built on a unified dichotomy. Consolidation is the suture pulling common facts together. Severance is the scalpel cutting away prejudicial complexities. Neither mechanism operates automatically. Both require emotion and rely entirely on the sound discretion of the judge overseeing the docket. Section 1 sacrifices granular separation to save time. Section 2 sacrifices time to save fairness. When evaluating multi-party hypotheticals, immediately look for the common threads of law or fact to consolidate, and identify the highly technical, prejudicial outliers to sever. Rule 31 provides the structural framework for litigation management, allowing the court to organize disparate claims into a single proceeding.